Welcome back to The Big One. Now, a member of the Supreme Court panel that ruled on the Abu Ramadan Evans Nimako EC case says the Supreme Court was clear in its judgment that the EC should delete persons with NHIS cards on the electoral roll. Justice Jones Dotse, speaking to journalists, said the Apex Court was emphatic that the use of NHIS cards was unconstitutional.
By the Supreme Court on the Abu Ramadan case, several people have interpreted it to suit the side they belong. The plaintiffs have indicated they would head back to court for interpretation in 2014. Former National Youth Organizer of the People's National Convention, PNC, Abu Ramadan and Evans Nimako won a suit in which the Supreme Court unanimously ruled that the use of the National Health Insurance Card in registering voters was unconstitutional. Following the 2014 ruling, the former PNC National Youth Organizer Abu Ramadan and Evans Nimako went back to the Supreme Court this year, seeking among other reliefs a declaration that the voters register was not credible for the polls in November. The EC had insisted that the Supreme Court's May 5 ruling on the voters register did not instruct them to delete the names of those who registered with the NHIS cards as proof of identity ahead of the 2016 general elections. But speaking to journalists Thursday morning, a member of the panel, Justice Jones Dotse, said the Apex Court was very clear in its judgment.
The Supreme Court was quite forthright and clear that the use of the NHIS cards is unconstitutional because the criteria for the NHIS card was not based on Ghanaian citizenship but only on residence in Ghana. So any foreigner who is resident in Ghana for 6 months and more can register under the NHIS cards. That was the basis upon our decision in 2014. And the recent one, we said the use of the NHIS cards is therefore unconstitutional. They should take the opportunity to clean the register of those undesirable persons. Therefore, we also did not want to disenfranchise anybody. So the Supreme Court went on to say anybody who will be affected by that exercise must be given the opportunity to register according to the law and the Constitution. That period. That's it.
Justice Jones Dotse said persons struggling to understand the ruling should come back to the court.
Right, very interesting dimensions of the law. Let's quickly get onto the telephone lines and speak to private legal practitioner and a lecturer at Central University, lawyer Yao Opong. Good evening, sir. We're grateful you could join us.
Yes, good evening.
I'm not old enough to have heard Supreme Court justices who were empaneled on particular cases speak so openly about it like this. Was it prudent for Justice Jones Dotse to have come out with his remark this way?
Of course it was, and it is done all the time. I mean, at conferences, you get judges making comments over decisions that the Supreme Court has given. Sometimes adverse comments. And the courts have, time and again, departed from their own previous decisions. Are they not making comments about those decisions? Today, I'll be surprised if any court, the Supreme Court, will want to go back to the decision in the Inria Akuto case. They have departed. So these are things that are usual. And therefore, well, I'm surprised that some people are using sometimes unsavory words at the law lord. And I'm saying that there's nothing wrong with what he has done. There is no suit pending in respect of the matters on which he expressed his thoughts. He's a citizen of Ghana. He's entitled to express his position. And in any case, he didn't make any comment which is different from what the Supreme Court had said in the first Abu Ramadan case and in the second case. So what has he said wrong? It is clearly within the right of the judge to make such comment. And there's nothing wrong. I don't see anything wrong with it.
Right. So quickly, would you say that with this, the whole matter or concern with the ambiguity of the interpretation from that ruling should be put to rest, and for example, that Abu Ramadan should withdraw his threat to take the EC on further?
Well, in the first place, I have never seen any ambiguity in that decision, and I'm not one of those who have manufactured or invented an ambiguity about that decision. The decision was clear. The decision was clear. The orders made were clear. Delete names and, as the judge put it, of those undesirable persons from the register, because it doesn't make it reasonably credible because of the unconstitutionality. The unconstitutional act that resulted in they finding their names in the register. And that when you do so, give them the opportunity to prove the eligibility and register them. Obviously, they were not asking the dead people to be resurrected to come back, neither were they endorsing the calling of minors that after their names are deleted, they should come back. It was in reference to those Ghanaians who, in view of CI-72, found their name by the use of the NHIS card, found
into
their
the
name
voters register.
in it. So
Right.
that is what they were referring to, and not reference to the deceased or the minor. So in that case, I would say that there hasn't been any ambiguity.
Right.
Others found it convenient to create one.
That
and
ambiguity,
therefore,
right.
For example, I don't think it's for Abu Ramadan to go and see any clarification. It is for whoever is to comply with it and refuse to comply with it to go back to the court. Otherwise, when the court gives a decision against you and others are in it, you have to comply with those orders, because you don't have the right, or it's not within
To pick
you
and choose
to determine which orders of
which
the
orders
court
to comply with. Right.
Otherwise,
Lawyer
then the appropriate sanctions will be against you.
Right, Lawyer Yalpon, we're grateful. We don't have a lot of time, but we're extremely grateful that you could make time to join us on this discussion. Abu Ramadan is here. Mr. Ramadan, how are you?
Very fine.
Do you feel vindicated with this? I mean, the last time you were here, you were passionate that the ruling was clear and that the EC had no choice to pick and choose what it wanted to implement or not.
Clearly, that's Lawyer Upon has just reiterated. There was no ambiguity to start with. It's an issue of mischief that people wanting to situate a situation to suit their whims and caprice. But there was no issue of ambiguity in the matter. And for that, whilst you was talking, I was asking myself, is there even the need to even want to go to ask the court to interpret further? Because if in my mind I'm clear on what the ruling is,
exactly.
But if the commission, but I can also aid the commission.
And you think the EC should be clear also, or they are clear but are refusing
precisely,
to act that they're seeing.
Yes, but if the clarity is a problem, I can aid them by going back to court to ask the court to either interpret or cite them for contempt of it.
Would you say the EC should be reconsidering its stance on this ruling?
I fully expect Madam Charlotte Osei to do something about it to comply immediately, and I'm hoping before the judicial workers would resume their normal duties and call of the strike action, she will find wisdom in wanting to implement fully the orders of the court, so that we don't have another legal tussle on our hands. Because if not, trust me, when they call off the strike today, tomorrow morning we'll be back in court.
I get the impression that you are going to now retire your decision to go to court to seek interpretation on the actual ruling. I mean, should the
commission decide to take steps to implement fully the orders of the court. But if not, we'll help them get the full clarity they need so that they can implement fully the orders of the court.
There being those who have been raising questions about your intent to go to court in the first place, and I've heard media discussions in which they say that Abu Ramadan should learn to tread cautiously because the peace of our country is at stake. When you hear all of these, and then you hear Justice Dotse come out this way, how do you feel?
I ask myself, between myself and the commission, who should be treading cautiously? I'm out to get the right thing done. I want the rules of the game followed. I want the orders of the court followed. I want the real interpretation of the law fully implemented. And between myself and the commission, who is reluctant in doing anything in terms of, because I remember during this hearing, one judge of the court asked the commission, is it that the 2014 orders we gave, you didn't understand those orders, for that reason why we are here again to further clarify on those orders, to give clarity on those orders? Because if you had done something about it before, we wouldn't be back here dealing with this matter. This matter would have been a non-issue at all to come back to court with. So
it's agreed.
We were asking, okay, so the millions, can you define who the millions, can you tell us who the millions are? So that based upon the ruling, we can take action to clean the register, to get them regularize their registration in tandem with the laws, existing laws of our country. But they give us a deaf ear and refuse to even give us hearing with regards to how many people are on the register. Because if from 2012 to now, if the commission had taken steps to clean the register, by now we wouldn't be talking about registration. Probably the logo they launch will be the issue for us to discuss, to say, okay, it's good for us to have launched a logo. Really, the world-class election the woman is talking about is something that we are on course to deliver. But nothing of that from the commission.
So how long are you going to wait on the EC to implement or enforce the order from the Supreme Court? A case which you won.
My humble appeal since yesterday has been on the President, to His Excellency the President, to pay judicial workers, to take steps in resolving the problem between himself and the judicial staff of the judiciary, so that they can go back to work, so we can file our suit. So as long as they remain home, we don't have the opportunity to file a suit. Then I know this music is like Shatawale's Kai Kai. It's playing so well.
It's like Kakai.
Yeah, it's playing so well to somebody's ear. And the paymaster would not be ready to pay because he's busy dancing. But I wish the music will stop so that he can pay the workers, so they can resume, then we can go back.
So let me ask you my final question. Do you think it will make any difference to the fortunes of the PNC if the EC goes ahead to delete the names of people who registered using the NHIS cards and then allows those who have the relevant IDs to put their names back? Will it make any difference?
Very much so, very much so. The reason why I'm saying that is my candidate for Sisala West, whilst on election day, when Burkina Faso had crossed the border to come and cast their votes, when my candidate complained in the presence of the then district chief executive, all he said was, are they not black people or they are whites? These are Africans. These are Ghanaians and Africans. And you ask yourself, we are not having an African election. We are not electing an AU president or ECOWAS president. We are electing a president of Ghana. So if the register is cleaned and we regularize the register and make it such that we have only Ghanaians on the register, the true reflection, because there are presidents that have come and gone. I believe Liman's legacy will continue to live on.
Right.
And Liman's name will never die. The people of Sisala know what Liman did for them and the pride with which they beat their chest and said, this is the son of their soil. There's no way they'll turn their backs against a party that he founded.
Right. Mr. Abu Ramadan, we're grateful for your time. Abu Ramadan is a former PNC National Youth Organizer, and he joined us to discuss a statement that was made by Justice Jones Dotse, who sat on a case Ramadan took to court to get an order for the EC to clean the voters register.